Hello, everyone. It's my great pleasure to welcome you to the finals seminar in our series this quarter. Today, we welcome Tommaso Pavone, who is an assistant professor in the School of Government and Public Policy at the University of Arizona and a visiting researcher at the University of Oslo. He's an expert on the impact of law and lawyers on political development and social change, and the author of several prominent articles on preemptive reform and how politicians keep issues from reaching courts, the rule of law crisis within the European Union, and the political geography of legal integration. His book, Ghostwriters, Lawyers and the Politics Behind the Judicial Construction of Europe, relies on very deep archival research and hundreds of interviews to show how lawyers encouraged lawbreaking, lobbied national judges to uphold European law, and mobilized courts against their own governments, and in the process helped to bolster the European Court of Justice and the European legal system. It's a fascinating read. It's won multiple major awards, and so we're delighted to welcome Tommaso today to present this book and his research.
Thank you so much, Anna. I really appreciate it. I hope my microphone is working and the people on Zoom can hear me. But it's an absolute delight to be here and an honor. It's my first time here at Stanford. I'm recovering from a cold from last week. I'm going to do my very best not to cough, but please bear with. My voice is still a little bit suspect. From my new book, just out in paperback this month with Cambridge University Press, so it's finally affordable. And what I really want to talk to you about today is about law and politics in the European Union. And I want to start with a puzzle. The EU has no army. It levies almost no taxes. And its bureaucracy is tiny. It's comparable in size to that of a mid-sized city. Because the EU lacks the are so how can I law on the ground? The answer is that the EU governs not primarily via soldier taxmen to a transnational network of courts. As national judges apply European law in the cases before them, they become the street-level bureaucrats through which citizens are most likely to encounter the EU's authority in their day-to-day life. But why would these national courts play ball? Why would they turn to European law? The conventional answer is that courts did this in order to bolster their own power. This view came to be known as the Judicial Empowerment Thesis, and the story it tells goes something like this. Before the European Community's existence, each European state had its own domain of national law, displayed here in green. And if you were a lower court in a national judiciary, you were bound by your Supreme Court's interpretation of national law, or your decisions could be overturned upon appeal. But once the European Community was created, via the Treaty of Rome in 1957, a new field of international law was forged, along with a European Court of Justice, I'm going to call it ECJ today in short, that quickly proclaimed that European law trumps conflicting national law and could be directly applied by the humblest local judge. And those judges were presumably all too eager to pounce on this opportunity. Whenever they encountered a national statute or a Supreme Court decision that they disliked and that might contravene European law, they could rebel. They could refer these cases in earnest to the ECJ via a treaty mechanism known as the preliminary reference procedure. And through this alliance with the ECJ, national judges empower themselves to exercise judicial review, often for the very first time, to contest the decisions of their superiors, and to Europeanize domestic policy. This is a classic self-empowerment story of institutional actors like judges mobilizing a new field of law in order to bolster their own power. And it's the narrative that seduced my imagination as a PhD student. But then in the summer of 2015, I began visiting these national courts in 3 founding member states of the EU, in Italy, in France, and Germany, and something was off. I was butting my head with a very different reality, and it looked something like this. I encountered courts that were overworked and understaffed. I learned that to this day, most national judges haven't received any training in European law. I realized that overworked judges are reluctant to apply a new body of international rules that they don't know very well because they might make a mistake. And I learned that judges in civil service judiciaries are reluctant to rebel against their superiors. So, to become motors of Europeanization, these judges clearly needed a vigorous outside push. And that's the core argument of my new book. Far from cradles of judicial activism, national judges broadly resisted empowering themselves with European law because they were constrained by excessive workloads, lackluster legal training, and the careerist pressures of their judicial hierarchies. The catalyst of institutional change proved instead to be a ragtag group of what I'll call Euro lawyers who faced fewer bureaucratic shackles. Under the sheepskin of rights conscious clients and activist courts, these entrepreneurs sought out clients willing to deliberately challenge national laws. They then lobbied judges about the duty and the benefits of upholding European rules over national rules, and they propelled them to refer cases to the ECJ by quite literally ghostwriting their referrals. So behind the scenes, the judicial construction of Europe was largely propelled by lawyers who converted national judiciaries into transmission belts linking local civil society with EU institutions. Now, to sort of walk through this argument, I first want to briefly outline the research design that undergirds it. I'll show you some evidence of lawyers' impact, how Euro lawyering evolved over time, and some of its limits as a repertoire of change. And then I want to conclude with some broader takeaways about how the politics of European lawyers, what it can teach us about institutional change and political development. So my book draws on 15 months of field work from 2015 to 2018 in the 3 largest founding member states of the EU. That's in Italy, in France, and in Germany. Now, to pick my field sites, what I did is I mapped the distribution of all cases referred by national courts to the ECJ. You can see these cases here, where the larger the blue circle, the more cases referred to the ECJ by judges in those locations. And then I chose to visit some cities where judges have historically referred a lot of cases to the ECJ. And I counterbalanced these hotspots of European judicial enforcement with more intermediate and cold spot locations to try to figure out what was missing or obstructing judges in those places. Throughout all of this, I gathered several original bodies of evidence beyond the geocoded litigation data that you just saw on those maps. I conducted 353 interviews with lawyers and judges, and I sought out previously unavailable archival documents from the EU's historical archives, from local newspapers, and the personal archives of the lawyers themselves. And what I found is that Euro lawyers broke from conventional lawyering. We usually think of lawyers, especially Europeans usually think of lawyers as go-betweens. You've got a rights-conscious client who solicits the lawyer's services. That lawyer represents the client's interest before a capacious judge who then renders a decision. Instead, these Euro lawyers served as ghostwriters of judicial policymaking. They were the ones who actively sought out clients willing to challenge national rules. Those clients then performed agreed upon solicitations. And then when faced with overworked and undertrained judges, these lawyers would propose ready-made decisions that the judges would adopt. So whereas in the go-between model, agency sort of flows through the lawyer's a conductor of socio-legal change. In the ghostwriter model, agency radiates out of the lawyer, who becomes the hidden catalyst of court-driven change. Now, the pioneers of this ghostwriting were few and far between in the early decades of the European community in the 60s and 70s. My research led me to the paper trails of just 12 teams of lawyers. And as you might expect, these folks were not representative of the bar as a whole. They had certain distinguishing traits in common. First, all of them were old enough to remember surviving the Second World War. Some had their property expropriated, lost family members, or had their own close calls with death. So they were very skeptical of the power of the state and politically committed to a liberal project of uniting European states through law. As one of these entrepreneurs in Germany put it, quote, "I remember the Second World War. I remember the bombing nights. So we have a different approach to Europe. When I'm asked, what are you? I tend to say I'm European and not German. But I must be careful because you might say, Grandpa here is always talking about the war. But it's a fact that for us, Europe, it was a gift." Second, a majority of these lawyers participated in founding the first transnational lawyers' associations to promote the practice of European law. And here, the most important association was the Fédération Internationale pour le Droit Européen, FIDE, and its various national branches. And this was crucial because in the 60s, 70s, and 80s, almost all national law schools neglected coursework in European law. So the lawyers banded together to do what the law schools were not. And finally, as I consulted the writings and spoke with the pioneers who are still alive, it was clear that they saw their lawyering as a politics via other means. They were mischievous. They relished their capacity to trigger reforms through their litigation efforts. One of these legal entrepreneurs in Italy conveyed this pleasure in agency in these words. He said, quote, "You set the fuse and it exploded with big booms well into the 1980s. There was a sense that we could do the unthinkable. We were captured by the beauty of novelty. It wasn't about omnipotence, but about participating in the process of European integration, of course." Now, what's striking is that this handful of lawyers solicited almost half of all referrals to the ECJ through 1980 and almost 500 cases over the course of their careers. Some 88 courts interspersed across 74 cities solicited the European Court of Justice for the very first time when one of these lawyers showed up. And nearly half of those courts would never refer a case again unless one of these lawyers showed up again. That kind of begs the question, how did they do it? They did it through a repertoire of strategic litigation consisting of two key steps. The first was the construction of test cases, and the second was the ghostwriting of judicial orders. I want to bring this repertoire to life by telling you one of the favorite stories that I uncovered over the course of fieldwork. It's the story of how the European Court established the free movement of professional athletes in the European community. And it turns out that this case was ghostwritten by a Euro lawyer named Vilma Viscardini. Miss Viscardini was a trailblazer. She was the first woman admitted to practice in the Bar Association of her hometown of Rovigo in northeast Italy. She fell in love with a man named Gaetano Donà, who was active in the European Federalist movement. And in the late 60s, they picked up and they left for Brussels to work in the fledgling executive body of the European Community, the European Commission. And it was while they were in Brussels that Miss Viscardini recalls feeling like she lived in a bubble. Nobody back home seemed remotely aware of the European Community's existence. So in the early 70s, she moved back to Rovigo. She starts going to schools, to civic associations to talk about Europe. But people would look at her funny like she was recounting fairy tales. So she decided to shake things up via a mischievous lawsuit that would demonstrate the far-reaching impact that European law could have on people's lives. She zeroed in on the one thing that all Europeans seem to care about, which is football. You see, she knew that member states, including Italy, required that you be a citizen of that state in order to be employed in one of its football clubs. And she was convinced that this violated European community rules protecting the free movement of workers. So she reached out to a lawyer friend named Mario Montero, who happened to be the ex-president of the local football club, and she constructed a test case like this. Mr. Montero would task her husband, Mr. Donat, with publishing a recruitment ad in a Belgian sports magazine. Here's the ad from the archives. Come and play for us in sunny Rovigo, the ad said. Mr. Donat would ask to be reimbursed for the modest expense of purchasing this ad. And then Mr. Montero would refuse. Mr. Donat, you've acted prematurely. Don't you know that Italian law forbids me from even considering to hire foreign football players? So no reimbursement for you. And then Mr. Donat, in righteous indignation, would turn to his wife, Miss Viscardini, and sue before the local justice of the peace, who happened to be another family friend and practicing lawyer. And then once before that judge, Miss Viscardini provided the judge with a crash course in the A's, B's, and C's of European law and a ready-made judicial order of referral to the ECJ, which the judge adopted without changing a word. As Viscardini confided, quote, obviously, I had to prepare everything myself, writing both parties' briefs, as well as the judge's referral to the ECJ. And this was all possible because Mr. Montero and the judge were both lawyers who knew me and my husband personally and placed their maximum trust in us. This kind of ghostwriting of judicial orders might seem like a one-off, but it wasn't. I was able to verify that it happened time and time again. Because over the course of my fieldwork, I got lucky. The European Court of Justice finally opened its historical archives to researchers. So I was able to access dozens of the original dossiers of the first lawsuits to the ECJ, and I was able to compare the lawyers' memos with the judge's judicial orders. And what I repeatedly found was that lawyers would provide ready-made drafts of referrals to the ECJ that the judges would then copy and paste. A great example of this is from one of the first referrals by a lower court in France. This case was ghostwritten by another pioneering Euro lawyer, Lise Funk-Bretano, who was a Jewish survivor of the Holocaust and a lifelong Euro-federalist. In this case, Ms. Funk-Bretano challenged regulatory restrictions of dairy exports between France and the UK. And she found herself before the Commercial Court of Paris. And this court was infamous. Not only had this court never referred a case to the ECJ, but in a prior dispute, when Ms. Funk-Bretano had cited the Treaty of Rome establishing the European Community, the president of the court had interrupted and said, "Counsel, what treaty are you talking about?" So Ms. Funk-Bretano held the judges by the hand and engaged in what other Euro lawyers described to me as spoon feeding. She walked the judges through the A's, B's, and C's of the Treaty of Rome, and then she ghost wrote the exact questions that the judge could ask the ECJ, which were obviously framed to invite the European Court to dismantle national restrictions on trade. And the judge proceeded to copy this text without changing a word. We fed it into Turnitin.com or other anti-plagiarism software, there would be bells and whistles and red marks all over the place, right? But this kind of Euro lawyering also didn't stop in the 70s. It evolved, and in so doing, it exposed its own limits as a repertoire of change. Because although the first Euro lawyers might have been motivated by idealism, they had invented a modular repertoire of litigation that could be co-opted by a rising network of corporate law firms. Now, through the 1980s, big law was largely absent in continental Europe. It was hampered by state restrictions on the number of law firm offices and the number of lawyers that could practice in each office. But as the entry and lobbying of British and American big law firms slowly chipped away at these restrictions, then European big law began to take off. Here's sort of the growth across Italian, French, and German cities of corporate law firms ranked in two influential journals for specializing in European law. I call these Euro firms. By linking lawyers to deep-pocketed clients willing to fund these ambitious escapades to the ECJ, Euro firms plucked aspiring Euro lawyers from elsewhere and forged a corporate ecology of legal mobilization. And I know that's a little bit of a mouthful, so here's kind of what it looks like instead on a map. In blue is the distribution of Euro firm branch offices from the 1960s to the 2010s. And if we then superimpose some heat maps showing where local judges refer more cases to the ECJ in areas of darker red, over time, there's a clearly growing congruence between the two. And behind this congruence, the reason for it can be traced to the profound impact that corporate Euro firms have on the legal consciousness of judges. When I conducted, yes. It looks like it's similar to that in the early years. Exactly. Exactly, because this is before the era of corporatization. These are some of those pioneering Euro lawyers that were kind of going all over the place. And their clientele wasn't primarily large multinational corporations. But as those pioneers sort of pass and you start to get more and more of these corporate Euro firms like Gide in France, Gleiss Lutz in Germany, Chiomenti in Italy, those corporate Euro firms are primarily locating in wealthier global cities. But what you see when you go to these courts where more cases are being referred to nowadays, and you start asking around, what's driving all of this? They will emphasize the mobilizing role that these corporate Euro firms play. So when I went to visit global cities like Paris or Munich or Milan, judges there take applying European law and referring cases to the ECJ for granted because they're regularly mobilized by Euro firms. So for instance, this is how one judge in Munich regularly refers cases to the ECJ, how they put it. He told me, quote, "You don't understand EU law if you don't have contact with these big law attorneys that we've been talking about prior in the interview, who come to my courts every time. This is essential for me to understand how the game is played. You've got to hear it again and again." But outside of these corporate hubs of Euro lawyering, EU law continues to fall through the cracks. Judges continue to resist its application, resist European law as sort of distant or inapplicable. The representative here is what another judge in Marseille confided. She told me, quote, "There's certainly business lawyers elsewhere, but we don't see them in court. So for the judge in his everyday, European law remains very far away. It's because of this that we don't apply it. It's not in our DNA to solicit the European Court of Justice. We don't even know how to do it." So this uneven judicial enforcement means that the EU's on-the-ground power to govern through law, its sort of legal and judicial infrastructural power, remains distinctly patchworked. It varies based on place and based on issue area. What this means is that even as the EU has expanded its legislative attention to consumer protections, environmental protections, fundamental rights, the political economy of Euro lawyering on the ground has moved along a countercurrent. It's clustered in core economic fields like competition and taxation law of greatest interest to corporate clients agglomerating in global cities. Let me conclude with 3 broader takeaways before we have our conversation, and I'm really looking forward to your questions and to our discussion. And the first takeaway is that this isn't just a European story, because the protagonists of my talk and my book tapped opportunities for transnational policymaking that are on the rise outside of Europe as well. Over the past 3 decades, we've seen a proliferation of permanent international courts. But what's really significant here is that there's now almost a dozen transnational courts, these are the ones chronicled here in the darker gray, that emulate the European Court of Justice's reference procedure. So these are international institutions that empower citizens and civil society to challenge their own states through a transmission belt linking national judges with international ones. Now, not all of these courts are active or authoritative, but the institutional opportunities to engage in the kind of political lawyering that I've described have certainly expanded since the end of the Cold War. A second, more theoretical takeaway is that institutional actors, like judges, are not hardwired to expand their formal powers. In fact, it's often actors with little formal authority of their own who are the drivers of institutional empowerment. The judges that I met in person and in the archives had compelling reasons not to empower themselves with European law. And when they did, it was often because dexterous attorneys had put them up to it. Lawyers matter most precisely when judges are bureaucratically constrained as change agents, and they can exercise their agency behind the scenes without disturbing the appearance that courts and clients are doing all the work. And then finally, contra the sort of populist caricature of the EU as this ever-expanding, encroaching top-down bureaucracy, my book suggests that Europe was actually forged through a series of contingent, bottom-up actions that blurred the boundaries between the public and the private, between the national and the supranational. The EU and its legal order was only made real where private litigants could be cajoled into acting as public enforcers, where national courts could be pushed to identify as European courts. So the history of the EU is not the top-down history of the rise of a superstate. Instead, it's a story of how private actors with little formal authority creatively mobilize to remake politics and to tortuously build a polity that remains today nowhere as real as in the field of law. Those are my comments for today. I very much look forward to your questions and to our discussions, and thank you again for having me.
Why don't we open up to questions? Jonathan?
This one though, the central actors here are the lawyers in the story.
Yes.
And it seems like early in the story, in the early years, like in the 60s and 70s, it sounded like idealistic people who didn't maybe care that much about getting paid. But in my experience, lawyers like to get paid.
Yes.
And you later on talked about deep-pocketed firms that need corporation work. Which then leads to a different sort of patient. It's more like the story that allowed at the beginning, which is that there's a client from shop. Well, I perhaps through some creative European claim, and so I'll get one of these Euro law firms who will come up with a way to move this to the And so I guess it's a question: is that what you were saying? Are the drivers the firms, because it's in the area of competition law? Firms can really get things forum to it. Look, and it seems like very similar to the U.S., where a corporate might think that that they are more likely to get what they want through they're kind of thinking federal courts, and under some conditions, someone thinks they can get what they want at the federal level, and so then they start making claims in area that would have otherwise done it.
Yeah.
You get the drivers of the desires of the firms. Is that driver?
Well, okay, so that's a great question. I think what you can trace out over time is a passage from idealism to self-interest. So I do think that there's relatively little evidence that these early Euro lawyers were primarily driven by the desire to make money. And one of the key tells of this is that these Euro lawyers were, most of them, kept practicing well into the 90s and the early 2000s. They never ended up joining a corporate law firm when the occasion presented itself, where they would have ended up making an awful lot more money. Part of the reason is that the interest of corporate clients sometimes pushes them towards mobilizing European law, but sometimes that actually pushes them against it. For instance, if we think about competition law, sometimes firms are very reluctant to engage with competition rules that might actually run against their interests. So if you are a lawyer in a corporate law firm, and you specialize in European law, sometimes it's in your client's best interest for you to not mobilize European law and try to ensure that the national judge doesn't realize there's this corpus of rules that maybe runs against your client's interests. These Euro lawyers early on, though, they had a clear sort of directional drive. They were trying to dismantle national rules, national regulations by mobilizing European law. And they took on some of these cases where they really made very little money. Now, there is one element of this that I realized very late, and that might explain why some of these lawyers were able to get away with it. About half of these early pioneering lawyers had been employed in the European Commission and EU institutions before they then returned home and opened up a law firm. So what that meant is that they received a pension from the EU and they were not as dependent on making money from private clients. So it's not that these early lawyers, even when I asked them what was driving your activities, it's not that they denied the need to make some money, right? They had to make a living. But it's also clear that they took on cases that dealt with, where their clients were oftentimes small-time farmers, where there wasn't a clear return on their investment, because what they were mostly trying to do was to try to get European law mobilized and convert national courts into European courts. That's very different from what we see today. And part of this realization was from meeting a bunch of, aspiring Euro lawyers my age over the course of fieldwork. And I would tell them about these early Euro lawyers, and they would sort of chuckle somewhat bitterly because they would say, we could never do that today. We feel this intense pressure to go to Cleary Gottlieb and these large corporate law firms where it's not about idealism at all. It's about trying to increase the profit of your firm and your client. And sometimes that means doing so by sheltering those clients from European law. So it kind of cuts both ways.
Thanks. I have a couple of questions also, but maybe I'll just start with one, and then if there's time left, I can ask some others, maybe some other questions. So my first question is, you basically describe a very decentralized way for the EU to make sure that its laws are implemented and that people comply with their laws, even more decentralized than the story that is usually told. The usual story, as you mentioned, basically the crucial role is for the local judges. It's not even the local judges, but some idealistic lawyers. So if you look at it from the EU's perspective, is this would you say that this is a system that works, this degree of decentralization, or would the EU have been better off setting up, like in the US, a federal dual court system to make sure that its laws would be complied with and so on? Are there advantages to having this system rather than a US system of federal courts?
That's a great question. So we know from the historical archives of negotiating the Treaty of Rome that the political representatives of the member states were primarily interested in the design of the European Community's political institution, primarily the Commission and the Council of Ministers. And then there was a groupe juridique that was put in charge with drafting the terms of the Treaty of Rome and also the judicial infrastructure of the European Community, including the Court of Justice. And we know from the archival records that they were thinking about a federal court system like the United States, but they thought that they weren't going to get that past their political masters, that it was going to look too federal. And so instead, what they did is one Italian that was part of the groupe juridique, in particular, drew inspiration from the Italian system of constitutional referral that had just been established, where if you're an ordinary judge in Italy and you think a law involved in a dispute before you violates the Constitution, you could stay the proceedings and refer the case of the question of constitutionality to the Italian Constitutional Court. And they transposed that system that was applicable in the Italian legal system to the European legal system. The big challenge with a system that relies primarily on private enforcement is that over time, it tends to reify socioeconomic inequalities, and it creates major spatial and socioeconomic gaps in access to European justice. So this kind of patchworked, uneven judicial enforcement of European law is really quite striking. You can go from a city like Paris, where you can find dozens of judges who are very knowledgeable about European law because they're regularly solicited by armies of Euro lawyers to apply European rules. And so they end up training themselves and becoming specialists themselves. One judge in Paris, it described this as an incestuous social relationship between corporations, corporate lawyers, and judges in these specialized corporate chambers of the various courts. And then you go to Marseille, or you go to Napoli, or you go to Bari, and you can't find a single judge with whom to converse about the application of European law. And they're the first to say, look, if the lawyers aren't asking for us to apply European law, why would we spend time training ourselves in this field? We're very overworked. We're only going to train ourselves in fields over which we're regularly solicited, where problems keep recurring. So it makes no sense for us to train ourselves in European law. What that means is that labor and consumer protections, environmental protections, all these branches of European law that are very important and could really reshape some of those local communities and be invoked by clients, end up not being judicially enforced and applied. And so I think this is a real problem for the EU, and it requires the European Commission, in its role as guardian of the treaties, to take an active interest in enforcing European law using its prosecutorial discretion through infringement procedure. And I'm happy to talk about my views on that, because the Commission has not been doing the best of jobs on that lately.
We have a somewhat related question from Deborah Hensler, who says that her research in Europe focuses on the collective litigation mechanism. And she's saying that the politics surrounding this development have been oppositional, led by the US corporate lobby and its European national affiliates. And the political rhetoric, the US is a bogeyman captured by American entrepreneurial lawyers who are to be despised. What you are describing, she says, a contingent of European lawyers who in a different domain are similarly strategic and apparently likely to be linked to big law. The lawyers and corporate folks she's interacted with never refer to entrepreneurial lawyers in their midst.
It's an interesting comment, but I'm having a little bit of a hard time grasping it. The lawyers and corporate.
So I think she may be asking how the collective litigation mechanisms, which are led by these corporate large firms, are different from the kind of judicial construction that.
So I have to admit, I'm not 100% sure what the collective litigation. I don't know if we're talking about class action lawsuits or some other mechanisms. Deborah, feel free to clarify or help me out if you can hear. Let me.
So I think I've been invited to speak. So American class actions are in the process of spreading around the world. And Europe has been one area where that has occurred. And some of the action has been at the member state level. But in recent years, the effort by consumer rights groups, human rights groups, etc., has focused at the European level. And indeed, there is an EU directive that will go into effect in January, requiring all member states to adopt something that looks somewhat like a U.S. class action. And the long opposition to that has been led by corporate lawyers, corporate representatives who have painted the U.S. as being the example of where you don't want to be. And their most frequent description of why the U.S. is a bad place in terms of too much litigation is that we are the home of entrepreneurial lawyers. And so the people I speak to in Europe are horrified by the idea of lawyers who are investing in cases, who have strategic approaches to litigation, etc. And because those people are the ones I've focused on, these are people who would use private enforcement. I've never heard of European entrepreneurial lawyers of the type that you've just described. And so I was curious as to what might be your reaction to that description.
Well, thank you. That makes a lot of sense. I mean, European policymakers have long had an aversion to American adversarial chasing lawyer that is so attributed to American popular culture. And it's certainly the case that in areas like consumer protections, which is sort of the prototypical domain of what we would think of as the ambulance chasing lawyer, there's that fabric of protecting a lot of the public. So there are some people that are starting to do that, and some environments like clients have started to realize that. So it's not okay. Here. But I think the field is not yet leveled. The domain of corporate law, the litigation support structure for the litigation of intellectual property, competition, and taxation law of interest to corporations is much more well developed and robust than the counter forms of litigation in consumer protection or immigration rights, asylum, and the like. So there's still a long way to go. And in this way, I think the evolution of litigation in Europe is kind of moved in a countercurrent compared to the United States. If we look at the evolution of strategic litigation in the United States, it was first sort of mastered by corporate law firms during the managerial revolution in the late 1800s. And then you had the rise of public interest law firms like the NAACP and the ACLU that tried to mirror the litigation tactics of corporate law firms, but for public interest. And what I see in Europe, in some sense, is the reverse of that, where you have initially a kind of ragtag group of more public interest-oriented lawyers who develop repertoires of litigation that are then corporatized and co-opted by corporate law firms. So the trajectories, I think, are a little bit different. But as you say, the EU has been starting to try to incentivize public interest litigation in Europe. I just don't see it as thickly developed as in the United States.
Hi, thanks a lot for the great talk. So the question I had was actually a bit of speculation. To what extent do you think your findings are also applicable to the other institutions of the European Union than the court? So an example I had in mind is the European Commission and the comitology process. So when the Commission is being advised, guided by the group of experts in the very technical field. And well, obviously it doesn't go as deep in the history as your examples, but it's still pretty 25, 30 years old. And well, those experts, of course, they are not necessarily are lawyers from the big law firms. They can be technical experts. They can be lawyers. They can be, people who care for the cause. They can be people who are there because they want to advance their careers. Yeah. I talked to a couple of them and in different fields. And one of the things I heard repeatedly is the European law is made by the people who actually show up at the meetings and sometimes shout the loudest. So just if I can get your opinion on that.
It's a great question. So I think if you're interested in the lifeblood of institution, any institution is going to have these ghostwriters, right? These behind the scenes actors who, formally speaking, the buck doesn't stop with them. But at the end of the day, they possess more knowledge, oftentimes technical knowledge, and the time to draft policy or solutions that then policymakers sign their name to. Lobbying is another example of this. I think what makes these Euro lawyers distinct is that they're not institutional insiders. they're institutional boundary blurs or interlinkers. So what I mean by this is that these lawyers are not reifying the autonomy of European law by only living all their life in, the Brussels bubble and the bubble of EU institutions. They are moving back and forth between their local community, national judiciaries, and EU institutional spaces and trying to interlink them together. And that means that the impact that they have is one of kind of collapsing institutional boundaries and institutional embedding rather than to reify an institution and make it more inward looking and insular. And I think that's quite significant and important. It's one of the ways in which European law becomes so rooted on the ground is the fact that it cannot just rely on the European Commission and its infringement procedures, for instance. It requires clients to bring cases before local courts and those courts to then dialogue with the European Court of Justice. And these lawyers are trying to break down the institutional boundaries that are fragmenting those various spaces from one another.
In that case, I want to assert my my privilege. I was wondering if you could talk a little bit about the cold spots and perhaps more interestingly, the intermediate spots. So what accounts for the variation in this kind of activity?
Yeah, so the intermediate spots are difficult, and I have to say that they kind of fall out from my analysis in the book, where I end up really like many comparative kind of analyses. It's easier to compare extremes than it is to compare what's happening in the more intermediate areas. Let me speak really quickly about the cold spots. Cold spots tend to be fragmented markets for legal services where you tend to have lots of small law firms and solo practicing lawyers competing with one another. And what that means is that they try to latch on to any lawsuit that comes up on their doorstep. And what that requires is for these lawyers to become generalists. So that means they're going to take a divorce case today, a criminal law case tomorrow, a consumer protection case the next day. And because they're generalists, because they're trying to make a living in an increasingly fragmented institutional space, is that they can't really specialize in any one area of law. That makes it very difficult to specialize in European law, which is an added layer of expertise. You not only have to know EU rules, but you also have to know how those rules relate with national rules. And so you just don't have a legal profession that is incentivized to specialize in European law. And you also don't have a clientele that asks lawyers to specialize in European law. There tends to be, just as a general kind of sense amongst clients in Naples or Marseille or Palermo, that European law is the law of European states. It's this traditional body of international law. So it's multinational corporations and states that deal with it. It's not everyday folks embroiled in petty local disputes, which is mostly a misnomer. And so what you get is a situation where there are lots of European rules that could be applied, and they don't get to be applied. Judges aren't asked to apply them. Lawyers don't specialize in them. Clients aren't aware that they could be there to help them. So, yeah.
Okay, I'm going to push you a bit on this because to explain the hotspots, you focus on the idealism of the lawyers, right? Their personal stories, their motivation, their intent.
The corporate interests of corporate law firms. So the Euro lawyers aren't really responsible for where the hotspots get entrenched. That's a process that really starts to occur, especially in the 90s, as Euro lawyering corporatizes. And it's where corporate law firms locate that determines where the hotspots are, not where the early Euro lawyers practice, because they kind of took cases all over the place.
Okay. So then, I'd still push you on the intermediate because if it's just about sort of, the market for law, that's a demand story rather than the supply story that you're putting forth and explaining the hot.
Yeah. So there is, of course, this. I mean, so it's not that lawyers necessarily create their own demand. It's that lawyers recognize that it's in their professional interest to specialize in European law when their clients are corporate clients, which, especially if it's corporate clients that have offices in multiple European countries, where specializing European law can become a way to serve that client's interest across jurisdictions. And those clients remain dependent on lawyers and their tactical repertoires. It's not like unless they have their own in-house legal service with lots of European law specialists, and only the largest corporate clients have those, they still remain dependent on the tactical repertoires of these corporate law firms and their lawyers. But those lawyers are definitely more client-facing. They're going to specialize in the areas of law that allow them to best serve their corporate clients. So even though they retain a domain of tactical and strategic autonomy, and they're still the ones that decide how to ghostwrite referrals, whether to ask for a referral to the ECJ or not, and the like, whether to instead submit a complaint to the European Commission, clients are going to expect them to be knowledgeable about European rules. I think, well, I would sort of think of the key mechanism being the presence of these corporate Euro lawyers, because they're the ones that are interlinking the multinational firms to the national courts and asking for referrals. But the sort of independent variable, if you want to put it that way, would be probably the presence of these multinational corporations. But I think the key mechanism, and if you want to sort of trace out the process, it remains this domain of corporate lawyers that ends up being the interlinker and the mobilizer of national judges.
The law that law day-to-day.
Yes.
Versus.
Yes, exactly. No, absolutely. And that's exactly, so this is the European Court of Justice oftentimes gets criticized for being an economic court, for mostly dealing with competition, tax law, intellectual property. The European Court of Justice deals with the cases that are referred to it by national courts. And if the litigation support structure to activate the preliminary reference procedure is only well developed in those particular spaces, where it's those legal rules that matter most to the socioeconomic life of firms, for instance, those are going to be the primary cases that the ECJ deals with. And it's not going to deal with as many consumer protections or environmental protection cases and the like, unless it's the European Commission exercising its discretion as guardian of the treaties, bringing those cases via the infringement procedure.
Yes. You talked about the three larger founding member states. I was wondering whether you would think that the same would apply to the smaller member states. And the reason why I ask is because I could imagine that if you're a judge in one of these smaller countries, the three original ones at least, tended to be more pro-EU. In a small country, I guess for a judge, there's probably less honor and glory to achieve in the judicial system, and they may be more inclined to be nice or to try to achieve something at the European level. So maybe there could be reasons why it may be a little bit different. So I want to ask you what you thought about it. And my third question, if I can ask a third one, is about it's a very specific question in a way about the sports ruling that you were, or the sports case that you were referring to. And so the sports case, I guess, that has more notoriety is the Bosman ruling in the 90s and 96.
Yes.
So I was wondering what the relationship was between those two cases.
Great. So let me answer that first. So the Donat versus Montero case set out the principle, which is that you couldn't make the employment of a professional athlete in a national football club contingent upon citizenship of that state. And then the Bosman case opened this up even further by allowing football players or professional athletes to transfer from one club to another across national that have there were all of these other indirect and Belgian clubs only hire Belgian football players. So it was the fee system and the quota system saying that, you couldn't have quotas saying you can only have 2 foreign football players in a club or whatever. That's what the Bozeman ruling really does away with. What smaller countries have so much more now the Belgium and that we do know anecdotally that Dutch judges seem to have been less existent in European law, in part because already under Dutch constitutional law, international law already had this kind of supreme or primacy over conflicting national law. So that principle of international rules trumping conflicting national rules was not novel in the Dutch legal system in the way that it was much more disruptive in France, in Germany, and in Italy. And so anecdotally, it seems like potentially Dutch judges were less resistant to the encroachments of European law. On the other hand, I know a couple of sociolegal scholars in the Netherlands that have found similar kinds of patterns of there's lots of courts in the Netherlands that are undertrained in European law. They don't know how to enforce it, and they don't have the kinds of law firms. They don't deal regularly with the kinds of law firms that specialize in European law that clustered in places like Amsterdam. And so this kind of political geography of judicial under enforcement of European law, potentially, I'm not certain of it, might also apply even in some of the smaller member states. But this is a book yet to be written. I had to stop somewhere. I needed to come back and graduate from my PhD.
Are there any final questions before we're about to run out of time? Okay.
What some countries, and I mean the relatively new EU countries like Poland is doing, trying to actively prevent judges from actually referring cases to the Court of Justice. And obviously Poland is now having the issue with the rule of law in many aspects, and this is one example of it. But
yeah,
could you comment on that?
Yeah, so that's a great question. I think this research really shows you how dangerous it is for the EU's, call it infrastructural power, when you have, a wannabe autocrat like Kaczynski in Poland or Orban in Hungary that targets the judiciary first for co-optation. Because if you can co-opt the courts and choke off that transmission belt that links national judges to the ECJ, it creates a kind of blind spot in the EU's capacity to govern through law, because violations of European law that would be referred by national courts can't percolate their way up to the ECJ. That's why the fail-safe in the EU legal system is centralized enforcement by the European Commission. And I have some research recently with Dan Kellerman that suggests that the European Commission has been overall quite reluctant in the past 20 years to enforce European law centrally, in large part because the Commission has been there's increasing cross pressures between the Commission's hat as the engine of integration, the right of initiative to propose legislation, which requires you to work cooperatively with member state governments, including the Hungarian and Polish governments, so they don't veto things like a plan for a minimum corporate tax that the Commission really wants. Tension between that and its prosecutorial discretion as the centralized enforcer of European law that can take member states to the Court of Justice and seek the imposition of penalty payments when they violate European law. And increasingly, it's the Commission as the broker of policy intergovernmentally that's been winning out over the Commission as enforcer of European law. And the Commission will often say, well, there's always national courts. There's always decentralized and private enforcement. And what I'm trying to suggest in my book is that even in the best of circumstances, in member states in good standing that respect the rule of law, that's still not satisfactory because it creates inequities in the enforcement of European law. In the worst of circumstances, where judges are under pressure not to enforce European law or refer cases because they might receive disciplinary procedures, it's even more incumbent on the Commission to step in and do what judges cannot. And I think overall, the Commission has been failing in that duty. But we could have many more conversations about that.
On that incredibly cheerful note.
Sorry.
Thank you. So thank you very much. And thank you all for coming. And to our Zoom audience, thank you.
Thank you. Thank you so much. I appreciate it.